All right. Good morning, everyone. Welcome to today's American Community Media Weekly National News Briefing. I'm Sunita Sarabji, your moderator today and co-producer of our weekly Friday briefings with my colleague, Pilar Marrero. Does a president with one stroke of his Sharpie pen get to define who is American? That is the question President Donald Trump has posed to us in the abstract on his first day in office as he signed an executive order banning birthright citizenship. Birthright citizenship is enshrined in the 14th Amendment and has been regarded as a right extended to any child born in the US since 1868. Trump's executive order attempts to redefine the 14th Amendment and who can participate fully, that is, politically, socially, and economically in our democracy. The Supreme Court yesterday heard arguments from several organizations challenging Trump's executive order. It is, of course, too soon to get a read on the court's thinking, but speakers today will inform us about what's at stake for our communities and the various attempts to fight back against an order that would essentially create an underclass of millions of millions of children, I should say, and render many stateless. We are proud to partner with Asian Americans Advancing Justice, AAJC, to present this important discussion today. Our speakers include Professor Robert S. Chang, Executive Director of the Korematsu Center for Law and Equity at UC Irvine School of Law. Julia Gelat, Associate Director of the U.S. Immigration Policy Program at the Migration Policy Institute. Martin Kim, Director of Immigration Advocacy at Asian Americans Advancing Justice, AAJC, and Cesar Ruiz, Associate Counsel at Latino Justice. We ask reporters to enter questions in the chat. We will go to Q&A immediately after each speaker presents, and we will send a video along with expanded bios later this afternoon. So let's begin with Martin Kim, who will provide a broad overview on banning birthright citizenship and the lawsuit currently before the Supreme Court and AAJC's position. Welcome, Martin.
Hi, and thank you for that gracious introduction. Hi, everyone. As was stated, my name is Martin Kim. I use he, him pronouns, and I'm the Director of Immigration Advocacy at Advancing Justice, AJC. So I know that Professor Chang will cover this in more detail, but I wanted to start just by very briefly highlighting what's at stake, what the historical context is on these attacks on birthright citizenship. And specifically, I wanted to mention that opponents of a free and open society have always seen usually the idea, the principle of birthright citizenship as a threat to their racist, exclusionary vision of the US. Even before the 14th Amendment, slavers in the early days of the US pushed for a restrictive view of citizenship. And as I'm sure Professor Chang will cover, the history of Asian American immigration and the Asian American population is deeply tied to birthright citizenship. So let's turn to what attacks we've seen. President Trump had issued an EO early in this second term purporting to end birthright citizenship for certain children. Now, we have to understand that this idea, this attack, this executive order is based on a fringe theory, a fringe legal theory that tries to expand the one limiting clause of the 14th Amendment, right, subject to the jurisdiction thereof. But it is our position that the president cannot change the Constitution through an executive order, cannot just sign a piece of paper that says these people are citizens and these people are not citizens, because the 14th Amendment means what it says, and that's been held to be true since the late 1800s, right? Everyone born in the US, absent some extremely narrow exceptions, are US citizens by birth. So there have been several lawsuits around this unlawful attempt to restrict birthright citizenship. Three of those cases were consolidated and argued before the Supreme Court yesterday, as many of you are aware. And yes, of course, there are arguments in that lawsuit around the legality of what the Trump administration has attempted to do. But the core of the arguments yesterday were around a procedural issue and a main focus of the government's arguments, which is the limits that are present or should be present on nationwide injunctions. And that's because the three cases they were heard, they're coming out of an emergency appeal. And what that means is any decision we're likely to see is unlikely to reach the core question of the legality of the executive order that the Trump administration attempted to implement. Okay, so that's the birthright citizenship. That's the case before the Supreme Court. What's at stake? Sunita already mentioned there's an extremely large population of people that could be directly affected by the EO. The EO stated that that it would be future facing. It's not meant to strip citizenship away from people who are already citizens. But that being said, our main argument, what we've been saying as we've been responding to the CEO, is that the idea that citizenship can be taken away based on the whims of a single person, President Trump, actually weakens citizenship for everyone, not just those directly affected by the executive order. And that's because we can see what this could lead to, right? The EO, of course, explicitly targets those individuals who are born to parents without immigration status, also those who are here on a temporary visa. But the actual argument that President Trump is making and his administration is making is that the president has the power to unilaterally decide who gets to be a citizen in the US. And that is obviously a very dangerous proposition. Okay, so I know I've been talking, hopefully not too rapidly for people to follow. I've covered, I think, a broad view of birthright citizenship, the case, and our position. One last thing I'll say, of course, there are several Asian American groups that are interested in this issue that have been involved in the lawsuits. We are also, AAJC has filed a lawsuit as well. It was not one of the three that was argued before the Supreme Court yesterday. But part of the reason for that is, as I'm sure the professor will get into, a, a lot of the formation of Asian America in this country is based on birthright citizenship, right? And the seminal case on this issue comes out of an Asian American's lawsuit against the government that tried to refuse that person's citizenship. So it is really historic and deeply tied to Asian American identity. So I'll pause here. I think I'm supposed to give some I'm supposed to give some time for folks to see if there are any specific questions, and if not, I can pass it back to Sunita.
Yeah. So reporters, please start entering your questions in the chat for Martin. But I'll start out with a few questions that I have, Martin. How will we handle newborns if this is comes to fruition? How do we handle newborns? It seems that currently there is no plan for implementation. Is that right?
I mean, I think that is exactly one of the problems that was identified in the arguments before the Supreme Court, right? It is clear actually that this administration this is not the first time this administration has taken this approach of seeking to break something without understanding it, seeking to overwhelm the community with fear and confusion without really thinking through the consequences or a plan for implementation. And that is a problem, and that is obviously something our community is concerned about. There isn't clear guidance as to what might happen if this executive order was to proceed. I know the executive order includes some kind of boilerplate language about agencies looking into implementation, but to date, we don't have a good sense of how it would actually be implemented, especially if there is if the Supreme Court does decide that, a nationwide injunction is not appropriate, that maybe it would go into place in some states and not other states. That would create a lot of confusion and a lot of headache for not just obviously the families, but the states, the hospitals, states that have to issue birth certificates, hospitals that have to figure out like what to tell their patients. There's a lot of concern.
So what is the status right now? Can hospitals actually issue birth certificates to newborns who do not have documented parents?
So nothing has changed in terms of the Constitution at this moment, right? Again, our position has always been the 14th Amendment says what it says. The president can't make up a new definition willy-nilly. The EO continues to be paused. The EO is currently blocked, and we continue to monitor to see what happens both in the Supreme Court and in the many courts where challenges have been issued.
Henrietta Burrows has the first question. Henrietta, welcome.
Thank you, Sunita. Martin, what do you think what can we expect from the Supreme Court? What are the options in terms of the ruling that they can make?
So as I mentioned, right now, the core focus of the arguments that we heard yesterday were around this question of whether federal courts can issue nationwide injunctions. I'm sure some of the other folks on the call may want to weigh in with predictions. I don't feel confident predicting what the Supreme Court will do in this case. I think there has been a lot of discussion about that particular issue. I don't expect there to be a ruling from the Supreme Court anytime soon on the merits of the case. Again, the way this case got to the Supreme Court is through an emergency appeal. And as such, we expect them to rule on this relatively narrow issue.
I have another question for you, Martin. Because of our fairly broken immigration system, there are currently about 1.5 million Indians who have spent many years in the green card queue. How would they be impacted by this executive order, if at all? Are they deemed legal permanent residents, or are they deemed temporary visitors?
I'm not entirely clear on the core of the question. I think what I'm hearing is what effect will this court case or the executive order on birthright citizenship have on other aspects of our immigration system, including people in the backlog? Well, again, the executive order purports to target children born to parents who are undocumented or here on temporary visas. There are a lot of people that do not fall within that category, including, but folks who with pending applications for green cards, who do not have other forms of status could possibly fall within the definition of the EO. But I'm not sure I fully understand the question. So
yeah,
that's probably
no,
the
I
best
was
answer
asking
I can
about
give.
people with work visas. Are they considered temporary visitors, or are they considered LPRs?
Well, if they don't have a green card at the moment, I don't, I believe they'd be temporary visitors, but I would have to look back at the executive order.
Fair. Well, thank you very much, Martin. We will move on to our next speaker, who is Julia Gillot. Julia will discuss MPI's newly released findings on the impact of banning birthright citizenship. The report was released on Tuesday, and I will provide a link to the report in the chat. Welcome, Julia.
Thank you, Sunita, and it's nice to be with all of you today. As Sunita mentioned, I'm going to share some of the findings of some analysis that we did of the potential demographic impacts of President Trump's executive order on birthright citizenship. My background is in sociology and demography. I am not a lawyer, so I'm very glad to be joined by these esteemed lawyers who can answer legal questions. But I can share what we found in terms of how this executive order could affect the size of the country's unauthorized immigrant population. And this is work that the Migration Policy Institute did with our non-resident fellow, Dr. Jennifer Van Hook, who's a demographer at Penn State, and also my colleague who's a senior fellow at MPI, Michael Fix. We started with the understanding that the goal of President Trump's executive order on birthright citizenship is to reduce illegal immigration and to shrink the size of the unauthorized immigrant population. But what we find is that if you look at the likely impacts, it would do the exact opposite. The executive order would grow the unauthorized immigrant population by 2.7 million people over the next 20 years and by 5.4 million people over 50 years, compared to the size that the unauthorized immigrant population would likely be under current understandings and interpretations of the 14th Amendment. This reflects an estimate of the number of children who would be born in the United States to an unauthorized immigrant or a temporary visa holder and would therefore be born without citizenship or legal status in the United States. And then we also estimated how many of those babies born here would live out their lives in the United States without gaining legal status. Within these numbers that I gave, the 2.7 million in the next 20 years and 5.4 million over the next 50 years, we estimate that 1.7 million of those people would be born in the United States to two US-born parents, but would nonetheless be considered to be unauthorized or here without status. Those 1.7 million US-born people with US-born parents would be the grandchildren of today's unauthorized immigrants or temporary visa holders. Therefore, this executive order would have multi-generational ripple effects if it was allowed to go forward by the courts and stayed in place. We also modeled an alternative scenario to show what would happen if the Trump administration was successful on some of their other immigration goals. If we imagine a scenario where there's no illegal immigration starting today, and the rate of immigrants leaving the United States doubles because of higher deportations and more people choosing to leave the United States, even under that extreme scenario, which we do not think is likely, the unauthorized immigrant population would still be larger under President Trump's executive order than under current policies and interpretations. It would be 1.3 million people larger. Another way of looking at this is to look at the number of babies born in the United States each year who would be affected by the executive order. So before I was talking about people that we projected would live out their lives in the United States, but there are a larger number of babies who would be born each year in the United States without citizenship or legal status. And we estimate that number at 255,000 babies born in the US each year without citizenship or legal status. That adds up to 12.8 million births by 2050. Again, some of them might live out their lives in the United States and some might not. In the piece, we also look at some of the larger impacts of changing birthright citizenship policies. Without birthright citizenship, millions of US-born children would grow up in the United States without access to public benefits during times of their family's economic need. They would grow up without access, in many cases, to financial aid to pay for college, and they would grow up without the prospect of being able to have a professional career and work legally in the United States, since they would also lack work authorization. Rescinding birthright citizenship would threaten the United States' exemplary record of immigrant integration, in which children of immigrants surpass their parents in terms of their economic and social integration and success. It would also exclude US-born workers from legal employment at a time when immigrants and their kids are driving all of the labor force growth in the United States because of population aging. And as has been mentioned already, it would create big administrative costs and burdens that would affect not just immigrants in the United States, but all of us, as we would face new administrative burdens and paperwork challenges to prove our citizenship and the citizenship of our children born here in the United States. So those are some of the larger arguments that we included, but the primary focus of the piece is really to emphasize how rescinding birthright citizenship would have the unintended consequence of actually growing the unauthorized immigrant population rather than shrinking it. I know I gave you a lot of numbers, so I'm more than happy to answer any questions that might have come up.
Yeah, Julie, I think the first question that comes up is, what happens to these children? Are they essentially stateless, or would they be able, and I know this might be a question for the attorneys, so would they essentially be rendered stateless, and could they get citizenship from their parents' home country?
It depends on the home country's policies. Kids who are born in the United States to Mexican citizens can get Mexican citizenship, and their parents could take them to a Mexican consulate here in the United States to register. But there are many people who would face barriers, even if technically their home countries or their parents' home countries' laws would allow them to have citizenship. For example, somebody born in the United States to somebody who's Venezuelan, maybe by the Venezuelan law could have citizenship, but there's no consular network for them to go and register and sign up for that Venezuelan citizenship. Or somebody born in the United States to an asylum seeker who is not comfortable going to their home country's embassy or consulate. One example would be, say, a Russian journalist who fled Russia and came to the United States. They may not be comfortable going into a Russian embassy or consulate to register their US-born child for citizenship. So we don't know how to estimate the number, but we do think that a lot of these US-born children could be stateless. And the other thing I would say is that, and I believe Martin touched on this, there are just so many questions about how all of this would be implemented. If you were born in the United States to parents who have temporary visas, like an H-1B visa, do you get a derivative temporary visa? We don't know. That would require further changes to US immigration law. Or would there be opportunities for you to adjust your status over time? That situation is not contemplated in our immigration laws because it doesn't exist. So there are just endless numbers of implementation challenges, both for the states and for the federal government.
Interesting. We have a question. What is happening globally with the population of stateless people? Where can essentially stateless people go?
I'm not sure I can speak very knowledgeably about that. I know that this is a problem that's particularly a problem for travel. I think some countries are better than others at recognizing that there are stateless people in their borders and addressing the challenges that those people face, and other countries may be less concerned about their situation. But that's about what I can say on that topic.
Yeah, absolutely. I wanted to ask, has MPI done studies of second generation kids who are born to undocumented parents, have birthright citizenship, and where they end up in the US economy?
We haven't specifically looked at that, but in the piece, we linked to a big National Academies of Sciences report that looked very broadly at immigrant integration in the United States and intergenerational mobility. And I know that other academic scholars have looked specifically at children of unauthorized immigrants. And what study after study finds is that children born to immigrant parents tend to surpass their parents. They tend to have more years of educational attainment, higher earnings, more prestigious careers. They tend to integrate strongly into US society and into our body politic. And we think that citizenship is such an important part of that because when people grow up in the United States without seeing a future for themselves, they don't invest in their education sometimes. They may not feel a part of the fabric of the country, and that can have real implications for their development and the pathways that they take in their lives.
Thank you. There are a couple of more, there are a couple of questions for you. Orhan Kurt, could you please ask your question and identify your news organization?
Thank you. So I know some family, they just coming here for during the pregnancy and getting the citizenship. So basically, is there any health tourism here? And if so, do you have any number?
Yes, I think certainly there's health tourism, and then as you're indicating, there is also birth tourism, people who travel to the United States expressly to have their child born in the United States, maybe as an insurance policy in case something happens in their home country. The Center for Disease Control, the CDC, reports that about 9,000 of the 3.6 million births recently in a recent year. I don't have which year that was. I think that's an average of some recent years, were to non-resident mothers. There have been estimates that are a little bit higher, but the highest estimate I've seen, which also had some questions around it, was about 30,000 births to tourists in the United States in a year. That is a real concern. That is an abuse of our birthright citizenship policy, arguably, but there are narrower policy changes that could address that related to visa issuances and the policies around that, and related to the rules that airlines have about people traveling while pregnant. So using a change in the interpretation of a constitutional amendment is a very, very wide change to address what we think is a fairly small but real problem.
Thank you. Michelle White Mendoza has a question. Michelle, please ask your question and identify your news organization.
Hello, good morning. Thank you for this timely press briefing. Yes, my question is, what would happen to children born from a visa holder, from a legal visa holder, mom, but that have been living abroad for many, many years?
Martin, do you want to take that question on, or Cesar?
So again, the executive order, in its own words, is restricted to people born to children born to undocumented individuals, or children born to folks who are on well, it's a little bit complicated, but who, generally speaking, who are here on temporary visas. So the kind of time someone's been on a temporary visa is not considered, right? It's a really restrictive view of who would be eligible for birthright citizenship. One that is not currently, one that is not in line with historical practice or, what we believe the Constitution mandates. So hopefully that answers your question.
And then one final question from Henrietta Burrows again. Henrietta, please ask your question. Henrietta? I'll ask her question for her, and it's a broad question. So then,
thank you, Sunita. I can do it. I'm sorry, I wasn't able to unmute. Thank you.
No worries. Please ask your question.
So what would then be the requirements for U.S. citizenship? Is it only given to American citizens who have children born in America? I've heard some talk that there might even be considerations of taking away citizenship, let's say from convicted felons. So then would there be requirements, specific requirements for people who can be considered citizens born in this country? And is it possible that that citizenship can be taken away?
What the executive order says is that a baby born in the United States would have U.S. citizenship at birth if at least one of their parents was a U.S. citizen or a legal permanent resident, otherwise known as a green card holder. So anyone born to two unauthorized immigrant parents or two parents on temporary visas or one of each would not have U.S. citizenship at birth. In terms of U.S. citizens losing their U.S. citizenship, I'll see if my lawyer colleagues want to add anything, but what I would say is that there are rare cases of people who are born outside of the United States but naturalize, who become U.S. citizens, who later lose their citizenship. That can happen in a pretty narrow set of circumstances, especially when there was fraud in their citizenship application and a federal court has to weigh in. I'm not aware of any mechanism under current law for somebody born in the United States as a citizen to have their citizenship taken away. But again, we'll defer to legal colleagues on gray areas of the law that might exist there.
I mean, this is not necessarily related to birthright citizenship, right? This is, but the Trump administration has stated that they would like to increase the number of folks who are stripped of citizenship through denaturalization. This is the same thing they said in the first administration, while there was a lot of talk during that first administration about possible changes. It was still a very small number of individuals who were affected by those efforts. But what I'll say is, of course, there is a risk, and that is the thing we're trying to emphasize, right? Is that they are attacking the sacred foundation of birthright citizenship, right? Because they understand that birthright citizenship is a barrier to enact the kind of regressive, outdated view of the U.S. that they see as good, right? They want to see, there are folks in the administration, there are folks who support the administration who are explicitly white nationalists, who are racist, who do not want America to be a country where, do not want to extend citizenship to certain individuals, certain communities. And that's why one of the reasons folks have been so outraged and so have advocated so strongly against this purported this effort to change birthright citizenship.
Thank you. Cesar Ruiz, before we begin with you, Mira Kaimal of India Currents has a question that I think you might be able to answer. Will the Supreme Court bench be hearing arguments about whether revoking birthright citizenship is actually unconstitutional or not? And if not, why?
I wanted to uplift one thing that Martin had stated in his presentation, which is really important. There are a lot of unknowns because one of the key questions that the court has to grapple with is whether the president has the power by virtue of executive order to change the Constitution, which presents a constitutional crisis in many ways. And we know what the law says in the amendment. We know what the law says in terms of the statutes in the NIA, and we know how laws have been interpreted. But to ratify this form of power and to give this power to the executive would create a lot of unknown, unintended consequences, because it would give a lot of power to the president to determine some of these very questions, and which is why so many groups have rallied around fighting the law. Now, to the second question, Martin also eloquently stated what is currently before the court and what will be before the court. So the narrow question that was before the court in the most recent arguments really dealt with what power does the court have to stop something that the president does? And does that have to be localized, or can there be national? And that was a key question that the court will have to reconcile with. And that's part of a larger fight about the power of courts to enjoin presidents, and a larger question within that. Now, Martin also mentioned that the court will be hearing this on the merits. It will be hearing the actual issues. But because this was brought through a mechanism known as an emergency appeal, it didn't reach the underlying question. So to answer your question directly, this will be heard by the Supreme Court. The timeline's not clear because the matter will be sent down, but this procedural question would be answered first and then briefing schedules would be set, and then it would have to work its way through the appellate process. And that timeline right now isn't clear because the decisions are essentially caught on a pause until the Supreme Court decides this procedural issue. And so, yes, it will be heard. It will not be heard on a clear timeline until they know the answer to this piece of the puzzle, which is a procedural question, a technical one.
Thank you. And you were going to discuss the impact of banning birthright citizenship on Latino Americans and the lawsuit that you all filed in February. So please go ahead.
Yeah, thank you so much. And thank you to Martin and Julia for such great and really thoughtful presentations. So I'm Cesar Ruiz. I'm Associate Counsel at Latino Justice. Latino Justice is a civil rights Latino nonprofit. We've done work across many areas, including democracy, immigration, among many other areas of our work. A key area of focus for us has been the attacks on the immigrant community, but specifically the Latino community. And we knew that much of the rhetoric that informed the current administration's policies on the campaign trail put an extremely large target on the Latino community's back. We heard a lot of the rhetoric targeting Venezuelans, Salvadorans, and we've seen actions consistent with this intention. Birthright citizenship is largely the exclamation point on actions that we've seen that dehumanize and that try and strip away rights from Latino and other immigrant groups. And so in February, shortly after the executive order was put in place, we filed a challenge in New York. Now, New York has a rich history of welcoming immigrants. Ellis Island has been a symbol of hope for immigrants. And so we thought it to be very important to file a challenge in a state where an institution in the fabric of life is immigrants. And we represent two organizations and two individuals. The first organization is the New York Immigration Coalition. The second is Rural and Migrant Ministries. And these are two organizations that have deep connections to the immigrant community and that have selflessly advocated for their needs, even in the face of stiff opposition that the administration currently enforces. We also represent two pregnant mothers. And these are individuals that are directly in the crosshairs and who would be having children who would be deprived of their citizenship. And as many folks have mentioned, be rendered stateless under the order. And there are essentially four reasons why we brought this case. The first, I think, as many have reinforced, birthright citizenship is a human right. It should not turn on where your parents were born or any other arbitrary factor. It's a concept that's embedded not only in the Constitution, but in our human history. And so we found it very important on the basis of our values and what we stand for, and also just the rights of our communities to fight that fight. The second is something that really is an egregious overstep by the administration to target the Latino community. We've seen attacks on Venezuelans. We've seen attacks on Salvadorans. We've seen deportations of individuals, even with permanent status. Kilmar Abrego, that case deals with a legal permanent resident who was Salvadorian and who went through all of the proper channels, but was still wrongfully removed. The administration admitted that, and there's still a fight to bring this person home. And so the birthright citizenship, as I had mentioned before, only continued that pattern and practice of targeting the Latino community. And this follows the administration using the media as a tool to villainize the Latino community through the targeting of Venezuelans, Salvadorans, and other Latino groups, saying that they are criminals, saying that we need to get them out of this country, saying things like they are poisoning the blood of our nation, things that stoke hate and fear, and things that directly have an impact on the lived experience of our community and the racial profiling that we know exists as a result. And so we really thought that it was necessary to take this stand. And we also recognize what Martin and Julia have talked about. There is no justification in the Constitution or in any of our laws for the position that this administration is taking. It is not supported through any statute. It is not supported through any constitutional provision. It is directly emboldened by the rhetoric of the administration and nothing more. And so we've really focused on the importance why, but we also want to uplift two more important points. We firmly believe that no president should have the power to simply rewrite our Constitution. That power is reserved for the people. and that power has not been vested in a president because that would create catastrophic issues. The fourth is that this is an issue that would fundamentally undermine all of the rights that flow from citizenship. It's not just the issuance of a birth certificate, but all of the rights that flow with that Julia, I think, so eloquently talked about. It is the right to work in this country. It is the right to travel freely. It is many of the privileges and things that we take for granted, but that flow from the virtue of you being declared a citizenship. And so citizenship is preservative of all of our rights, and it's something that is really important that we protect. And we brought this case because we thought it was important to speak to these issues in a way that humanizes the struggle of immigrants and that humanizes the issue, but also that maintains a bright line, that it may be this small targeted group today of individuals identified in the order, but there are seemingly no bounds to where this could end. And I think a lot of the questions that folks have raised those very questions is, if we're starting here, where do we go? And then it's for those reasons that we really sought to fight. So I'll pause there. I've said a lot for any questions that folks may have.
Thank you, Cesar. Nicole Chang has several interesting questions. Nicole, could you ask your second and third question, please?
Yes, my second question was, what are the risks to democracy and the civil rights if the birthright citizenship is restricted? And then, the policy perspective, I'd like to know what are the key factors driving these sustained efforts to regulate or curtail birthright citizenship, and how do these efforts align with broader immigration objectives? That was my question.
I'm happy to take a stab at the first. I think in terms of the risk to democracy, it would undermine the right to vote for both Latino and Asian community members and even African Black, right? Immigrants are not a monolith, even though it may be presented that way in the media. There are immigrants across many different ethnicities. And so this would severely undermine the ability of these individuals to enforce their rights, which one of them being the right to vote. So this would strip many groups across the ethnic and racial spectrum from that critical right to vote. And so it poses a really significant risk to our democracy that is already dealing with a lot of blows. I'm an election law practitioner by trade. We've done a lot of fights over redistricting. This would have a direct impact on representation in cities with large immigrant populations. Can't understate that. Across the board, it would have impacts on representation in battleground states that determine the president. And so across the board, we would see effects where populations of immigrants that would fall within the scope of the order, their children would be stripped of that.
Wow, that's a great point.
There's really no, and again, one of the risks here is that while it may be somewhat fixed in the executive orders are subject to change. The president could very well, if the court grants him this power, seek to undermine even more groups or call the immigrant or call the citizenship pool even in larger terms. And so that's why the key question and the uncertainties flow from whether the president has this power and how that power could be wielded. But some of the ostensible or more present threats are, this is stripping away power through redistricting and representation, and then this is chipping away at power of immigrants who have been a part of cities where that population is counted toward the census. And so those are some of the more direct ways that we could see impacts on democracy and some of the more tangible ones. And then to your second point, what policy is undergirding or supporting this? I think the position that we take as an organization is that this is xenophobic. These are sentiments that seek to target people on the basis of their ethnicity, of their race. This is a racialized and ethnic issue. The targets and the statistics show that overwhelmingly the individuals caught in the immigrant enforcement mechanisms are not people that come from countries in Europe or other areas. It disproportionately tends to be individuals who are racially profiled And so we take the view that there is extreme sentiments of xenophobia and racism that inform these policies. And that rhetoric was inflamed on the campaign trail and even through the actions of the administration that continue to target Venezuelans, Salvadorians, and Latino groups. And so that, among, I think, other factors, I think Julia talked about some of the policy issues that undermine belief and faith in the immigration system, but also there's no discounting the fact that the laws have not been updated to meet the needs of our current immigrant community. These are laws that were passed 40, 50 years ago that have not been updated to create pathways. And another part of this conversation that is not underscored enough is how difficult and how expensive it is to naturalize in the United States, and how that process is not really open and accessible to low-income individuals that migrate to the country. And so I think a combination of these factors really inform why, but I also think that Julia and Martin and other folks could also speak to some of the other factors as well.
Thank you, Cesar. Speakers, note that there are a bunch of very interesting questions in the chat, and if you could answer them there, that would be terrific. Our final speaker today is Professor Robert Chang, who will provide a historical perspective on birthright citizenship. Welcome, Bob.
Hi, Sunita. Thanks so much for having me. And there's so much to talk about. And I was asked to place this in historical context. And so when we think about this effort by the current president with regard to birthright citizenship, it's not something that is isolated. It's connected to the long history in this country. And so when we think about this, at the founding of this country, who got to be full members of this political community? Now, the Constitution itself does not say anything about eligibility for citizenship. It does say something about naturalization. It directs Congress to create a uniform law of naturalization. So what did Congress do when it used this power? In 1790, it created a law of naturalization that permitted free white persons to become naturalized. So free white persons, that's what Congress did. From the beginning, it restricted who could be full members of this community. And then many people may be familiar with the case of Dred Scott versus Sanford. And this is a case in 1857. And the question was, and it's funny because it was actually a very technical question about whether or not a Black person could sue in federal district court, because in order to sue in federal district court, he had to have been recognized as a citizen. And Chief Justice Roger Taney, in that opinion, said that Black people, regardless of how many generations they might have been free in this country, could never become citizens of this nation. And that actually precipitated a crisis that led to the Civil War. And then following that, there were attempts by Congress through the Reconstruction Amendments, the 13th, 14th, and 15th Amendments, to address this. And so the 14th Amendment was intended to undo the harm of Dred Scott and this notion that Black people could be full members of this national community. Now, it did leave certain questions unanswered, including, okay, so now that Black people can be recognized as citizens, well, I guess we need to change our law of naturalization. And so Congress did that. And it allowed then white persons and persons of African nativity and descent to be naturalized. Well, okay, so what about people who look like me? What happens to people who look like me? Well, in 1882, in the Chinese Exclusion Act that forbid laborers from coming into this country from China, there was an explicit provision, I think clause 14, that said that Chinese persons could not become naturalized. And so then, okay, so we can't become, people of Chinese ancestry can't become naturalized. What about their children? And that's when we get to the 1898 case that's been referred to of Wong Kim Ark versus the United States. So he is born in the United States. Is he a citizen? And the US Supreme Court in that decision said that yes, that was the interpretation of the 14th Amendment. He was born in the United States, subject to the jurisdiction, and therefore he's a US citizen. And since that time, and I don't have time to go through some of the other cases that confirm this, but we have an unbroken chain of 127 years of the recognition of birthright citizenship. But throughout this, there was still the effort to limit who could become citizens, because what about people who look like me? After this, could we become naturalized? And this is when, in 1922, the United States Supreme Court in Ozawa versus the United States said that a Japanese person could not become naturalized, even though he came to court and said, I'm white. He presented his skin to the court and said, I'm whiter than European immigrants that you let become naturalized. The US Supreme Court there said, well, white equals Caucasian, so therefore you lose. Well, the next year, a South Asian man came to the court and said, I'm Aryan, I'm Caucasian. You just said Caucasian equals white. I should be able to become naturalized. The US Supreme Court said, no, white equals somebody who does not look like you. Now, this has a devastating consequence, and this is critical in understanding a possible risk with regard to the current executive order. And so following the denaturalization of Bhagat Singh Thind, the US Department of Justice instituted denaturalization proceedings against the 60 to 70 South Asians who had been able to become naturalized. And so when we think about this executive order, sure, it said that babies born on February 19, 2025 and after do not have automatic birthright citizenship. But if the US Supreme Court upholds this executive order, it creates the risk of the possibility that everybody who has parents in those two categories who thought they were US citizens, well, they could have the US government denaturalize them. And so that's one of the risks. And that's the argument that we made in the Ninth Circuit on the merits in an amicus brief. So the Korematsu Center, working with the Center for Civil Rights and Critical Justice at Seattle University, and with Asian American Legal Defense and Education Fund, we pose the risk because we know what history has produced for us. And so then when we think about what is really at stake, it also goes back to Cesar's point about voting. I think this has to do with undoing the voting rights of everybody retroactively who falls in these categories, because states are responsible for registering voters. And so if a state wants to act on the executive order, they could say, okay, well, if you want to vote, you have to prove that your parents don't fall into these two categories. And if you can't prove that, then you can't register to vote in that state. And so there's all sorts of mischief that might be produced. But again, getting back to the historical perspective, this has to do with controlling who gets to be full members in this community. And this goes to a long strand of history where people of color have been targeted, either in terms of not being able to become citizens by birth, or through naturalization, and this is just one step. If birthright citizenship goes away, well, who determines who can become naturalized? It's Congress. Okay, so it goes back to the political branches. Once this is restricted, it opens the door to other limitations in terms of who can become naturalized. The stakes in this are so great. And that's why it's amazing to be part of an advocacy community that is fighting hard to make sure that this doesn't happen. And so I want to stop there because I hope I haven't gone beyond my 6 or 7 minutes.
You have not. That was very good. So Professor Chang, could you just talk a little bit more about how this opens the doors for, who can become naturalized? And to all of the attorneys on this briefing, do you see a process of reversal where people who have been naturalized have their citizenships revoked?
So one of the ways that this could be given retroactive effect, and again, I'm not conceding this because if this is done, I know that AJC, Latino Justice, and so many organizations will fight against it. But here's how the federal government could put this into action. So let's imagine somebody has a US passport and they want to have it renewed because it has expired. So then the US government could require, so the State Department then, so there could be a new executive order. The president says to the State Department, in order for any new passport to be issued or the renewal of any passport, the applicant has to prove that their parents don't fall into these two categories. And if you can't prove it, then you don't get the passport. They haven't technically denaturalized the person, but they've taken away one of the really important benefits that come with citizenship, which includes the ability to travel abroad, the ability to visit family and friends, the ability to go enjoy what other countries have to offer. So that's one way, without going the full denaturalization route, that they could use this to take away the little bundles of things, the rights that come with citizenship. But given the past history, if the Department of Justice wanted to denaturalize or possibly even engage in citizenship stripping, history teaches us that they've done it before, and this current effort is actually connected to those earlier efforts. And that's why many of us are so fearful about this. And part of this also is, even if they don't win this round, it softens the ground for future efforts. It raises the question, should we really be, should we rethink what it means in terms of birthright and citizenship and who gets to be part of this nation? It opens up this question in a way that I think is very dangerous during this political moment.
Thank you so much, Professor Chang. We need to go to a final question. I would like each of the speakers to give us your 30-second soundbite of your most important remarks, what you'd like reporters to take away from this briefing. Julia, let's begin with you.
Yeah, the key message really from our work is that repealing birthright citizenship for some children born in the United States would actually grow the unauthorized immigrant population. It would not shrink it. And I don't think that would serve the goals even of this administration. Thank you, Julia. Cesar?
I think we would want to share that we are here and that this fight is far from over, and that we're going to need not only everyone in our community, but the media to really stress the impacts and the importance of this fight. Julia talked a lot about the impacts, and that's just the beginning of the conversation. This conversation needs to really be fully fleshed out, and we need to come out on the right side of this. And the right side of this is that the president doesn't have the power, and that our Constitution guarantees us birthright citizenship. And that's all.
Thank you. Martin?
I would go back to the point that the idea that citizenship can be taken away from a whole class of people based on the whims of a single person actually weakens the power of citizenship for everyone.
Thank you, Martin. And Professor Chang?
I hope that people who are interested in this issue understand the connection to broader social justice, anti-racism efforts, including the critical issue that is now before the U.S. Supreme Court, again on the emergency docket, which is the termination of temporary protected status for Venezuelans. And soon coming up, it's going to be hundreds of thousands of others. So it's all connected, and I hope that people understand these connections.
Thank you to all of our speakers. We could spend at least another hour on this topic, if not longer. But I very much appreciate you all for being here. And reporters, we'll see you next Friday. Thank you again.
Thank you.